And now, today onward, we will discuss, the confession. We are scheduled to discuss confession. The provisions related to the confession in the Indian Evidence Act are from section 24 to 30. But along with these provisions, some provisions in the Criminal Procedure Code 1973 that are related to the confession also we will discuss, because my job is not only to read out the section and to just interpret those section and discuss the cases. My job is to give the whole, you know the wholesome discussion on the particular topic. So here the wholesome discussion cannot be done on the confession unless we will discuss some provision from the CRPC that was very much relevant on the confession. If you see section 24 of the Evidence Act, on the line of section 24, there is section 163. The voluntariness of the confession is very, very important. And to assure the voluntariness and that the no confession made before the police officer is admissible. So where to make the confession? Definitely the judicial officer. So section 164. But how that has to be recorded? How the judicial officer assure that confession is free from threat, inducement, promise, or the confession is voluntarily? Because voluntary confession is in itself is a substantive piece of evidence. No person can make a confession because it is against his interest. A rational person make the confession when he think and when he want to, regret for that. Otherwise, without being a voluntary confession, you cannot say that it is substantive and the everything is proved. And that's why it is utmost important to assure that the confession made by the accused is voluntarily. Section 24, section 25, you will see that section 24 makes certain confession are irrelevant. And section 5 says that the evidence of only the relevant confession can be, relevant fact can be given. When the confession in a certain circumstances itself is declared to be irrelevant, evidence cannot be given of that. And a voluntary statement became inadmissible when it is a voluntary statement, when it is voluntary confession, it is relevant. But because it is made before the police officer and we cannot assure that whether it is voluntarily or it was not voluntarily, because police officer is the part of the investigation. So his job is to finish that investigation, and maybe in that zeal कि कौन एविडेंसेस खोजेगा, कौन क्या चीज करेगा, चलो इन्हीं को पीट पीट के यहीं से कन्फेशन करवा देते हैं. So seeing that thing in the mind, the section 25 of the Evidence Act says that no confession made before the police officer will admissible. The word used in the section 24 is irrelevant. The word used in the section 25 is not admissible, that means inadmissible. So there is a great difference. And so guys, our discussion will be on these provisions that are the substantive law on the confession. Section 24, 25, 26, 27, 28, 29, and 30. And along with the procedural law or the adjective law that lies in the Criminal Procedure Code under section 163, 164, 364, and section 553. These provisions we will discuss. Okay. So first I'm taking the first, the certain issues we will discuss. The first thing is that what is confession? What is confession? If you see the Indian Evidence Act, it divided into three part. Then in the part second that we are discussing, in the part second also there are different chapters, and in that chapters also, there are groups. If you see that we are on this second chapter, and there on the second chapter we are on the group of admission. And so this confession, the provision with related to the confession fall under the group admission. And so we can say that because after section 30 there is another group from section from 30 to 31. After that there is another group, statement by the person who cannot be called as witness, section 32, 33. Then there is another group, statement made under special circumstances, section 34. So the confession fall under the group admission. And so we can say that the confession is species of admission. Confession is species of admission. And if you remember the definition of admission under section 17, that admission is statement. That statement may be oral, documentary, or in electronic record. And so similarly, the confession is also a statement that is oral, documentary, or in electronic record. So that is the first thing, that the confession is a statement. Then the second thing is that what type of the statement is the confession, how it is different from the admission. Or you can say that what is the confession, if you can say directly. Now it became very, very difficult, because earlier also we have discussed, because the word confession has not been defined under the Indian Evidence Act. And so what is the true meaning of the confession is really a big question. The difference or the definition also became the important, because the law related to confession is different, and the law that sort of the confession, that means only the admission is different. The law related to admission is from section 17 to 23, and that is different. The admission by one of the co-accused cannot be used by against the another co-accused, but the confession of one of the co-accused can be used by the another co-accused under section 30. And so it's become very difficult. Stephen, in his digest of law of evidence, he that is the book written by the Stephen, he said that confession is an admission made at any time by a person charged with a crime, stating or suggesting the inference that he committed the crime. And the word suggesting the inference that he committed the crime create a difficulty and the confusion in realizing the true import of the expression. And then, if you remember my earlier discussion, that the Privy Council has clarified that what is the true meaning of word confession in the Pakla Narayan Swami versus Emperor. In the Pakla Narayan Swami versus Emperor, AIR 1939 Privy Council 47. This judgment is now, remain with you throughout your legal life. Whether you will be an advocate, you will be a judge, you will be an academic life, you have to remember this judgment, because the word confession is not defined, and this is the first time the highest judicial body has defined the word confession. There in the Pakla Narayan Swami, the Privy Council said that the confession is the statement that admit the guilt in itself. Like, against me there is the charges of murder, so if I admit that yes, I committed the murder of this Mr. X, it is confession. If I commit that maybe in the detail that Mr. X used to give abuse, there was an altercation between me and Mr. X, and he used the abusive language, and so I got very much, very irritating and annoyed. And in that night, I woke up and then went and, you know, I stabbed the knife in the chest of Mr. X, and, you know, there was the pool of blood, and then, you know, he was not taking breath, and then I came back, but then I regretted that I did mistake, and it was on the sudden of movement and whatever, yes. So this is something where the accused, admit all the facts that constitute the offense. So the confession, you see, is very, very simple. You have to understand that the confession, two types of the statement may be confession. One, that you admit. One is that a person admit the offense in itself, and second is admitting all the facts that constitute the offense. Then any other statement, how so much it is incriminating, grave incriminating or conclusively incriminating statement, would not amount to the confession. Like the murder is committed by stabbing a knife, and you were in the possession of that knife, the recent possession, and you have no explanation that your knife has been in the another person. Then also it is just a suggesting fact, but neither it that you are admitting that you commit the crime, or you are admitting all the fact that constitute the crime. And so this fact that you are in the position of the knife, the weapon by which the crime was committed, is just, a statement fall short of the confession. Statement fall short of the confession means it is not an confession. Okay, it is, yes, it is very incriminating. आपको वो क्रिमिनलाइज कर सकती है, सजा दिलवा सकती, but it is not confession. Then this statement, then this definition, that is in the Daklanar and Swami, was followed by our Supreme Court in Palvinder Kaur versus State of Punjab. In the Palvinder Kaur versus State of Punjab 1953 judgment, the Supreme Court has observed that confession, same thing, the confession must either admit in term of the offense, or at any rate substantially all the fact that constitute the offense. The admission of gravely incriminating fact, even conclusively incriminating fact, in itself is not a confession. The statement that contain self-exculpatory or other matter cannot amount to the confession if the exculpatory statement is of the same fact which, if true, negate the offense alleged to be the confess. The statement which, when read as a whole, is of exculpatory character and which prisoner denies his guilt, is not confession and cannot use in the evidence to prove his guilt. Now this latter part that the Supreme Court said in the Palvinder Kaur versus State of Punjab, that there are two words. One is inculpatory statement, another is exculpatory statement. Inculpatory statements mean those statements by which you can be punished or that used against you, and exculpatory means when you are saying that you are not accused. Like, this word exculpatory or culpable is like the culpable homicide means जो जिससे सजा होती है. So suppose I said that I went to the room of Mr. X, the person whose murder was committed. This is inculpatory. Then I went there with the intention that today I will stab Mr. X. It is also inculpatory. And then I saw that someone was sleeping, and then I stabbed 5-6 times there. Okay. And then I saw that there was the dog who was sleeping in that bed like the man. So this second thing, this part that I killed only the dog, is the exculpatory part. Or in another situation, in another example, you say that I went, I did, but I did not did. So there is some statement that is used in favor of you or that denies your guilt is known as exculpatory fact. The statement that denies the fact is exculpatory. The statement that accept the guilt is the inculpatory. So if in a statement as a whole you see that there are many facts that you have accepted, but there is some part where you denies the guilt, that is exculpatory, and so it falls sort of the confession, and so this would not amount to the confession, and it cannot be used to prove that you were the guilty. Okay, now from these two judgments, Pakla Narayan Swami versus Emperor, the Privy Council judgment in 1939, and the Balwinder Kaur versus State of Punjab, the 1953. Later on, there are various judgments also that affirm the decision, given by the Pakla Narayan Swami. This is the well settled law that what is confession and what is sort of the confession. That means what would not constitute the confession. Highly incriminating and conclusively incriminating fact. Conclusively incriminating, you possess the knife and there is no possibility that someone steal it, then also it is not confession, because आपने guilt पूरी तरह से admit नहीं किया. Suppose you went there, you went with the intention to kill that person, and then you are not accepting, then just I did not kill. So this is something that where you denies your guilt, and this is the exculpatory part. So the confession cannot read कि exculpatory part आप छोड़ दो और inculpatory part you read it, सर यहाँ तक है और that means it is confession. No, you have to read the confession as a whole, and in that confession there is some explanatory statement that used in favor of the accused, so that cannot be the basis of the conviction. So the first thing that what is the confession we have discussed. Now come to the second thing. Second is that the substantive law of the confession lies in the provision section 24 to 30. And the procedural or the adjective law of the confession is in the section 163, 164, section 364 and 553. Now the substantive law of the confession, section 24, when the section 24 we read, it says, you also, find this section 24 in your Bail Act, whether it is in the physical form or in the digital form. Yeah. Confession caused by inducement, threat, or promise when irrelevant in criminal proceeding. The word used here is irrelevant. A confession made by an accused person is irrelevant in a criminal proceeding if the making of confession appears to the court to has been caused by an inducement, threat, or promise. Inducement I, threat T, and promise P. ITP भी कह सकते हो और TIP भी कह सकते हो. Threat, inducement, promise, as your convenience. These three words, but you have to remember. And this inducement, threat, and promise having reference to the charge against the accused person proceeded from the person who is in the authority and sufficient in the opinion of the court to give the accused person ground which would appear to him reasonable for supporting that by making it he would gain any advantage or avoid any evil of a temporal nature in reference to the proceeding against him. So basically, section 24 make those confession तो है, यानी उसमें एक स्टेटमेंट भी है जहां पे पूरा ऑफेंस एडमिट कर रखा है अक्यूज ने, या सारे फैक्ट एडमिट कर रखे हैं जो कि एट एनी रेट कॉन्स्टिट्यूट द ऑफेंस, बट जज को लगता है ऑन द फैक्ट ऑफ इट ऐसा नहीं कि उसको सपने आते हैं जज को, जस्ट इट अपीयर्स टू द कोर्ट दैट दिस इज नॉट वॉलंटरली, दिस इज समथिंग दैट इट इज थ्रू द इंड्यूसमेंट, threat or promise, and this inducement and threat or promise is from the person who is in charge of the authority. Okay, and this is with reference to his charge that it would gain some advantage or avoid any evil of the temporal nature in that proceeding. Like आपको किसी ने उठा लिया कि भाई साहब आपकी सोसाइटी में मर्डर हुआ है और ये जनाब कह रहे हैं कि आपको उस रात नीचे से देखा था, पुलिस ले गई एंड पुलिस आपको पीट रही है। उसके बाद में वो अपने आते हैं ना गुलशन ग्रोवर गोलगप्पे खाते हुए कि जिंदगी का मजा तो खट्टे में है। आपने कहा कि भाई साहब मुझे छोड़ दो इंस्पेक्टर साहब, मैंने कुछ नहीं किया, मैं तो बस पढ़ाई के लिए गया था, LLB का एग्जाम था, टेंशन हो रही थी, सुबह वॉक कर रहा था नीचे। उनका दर्द हो रहा है? आपने कहा हाँ बहुत दर्द हो रहा है। एंड ही सेड that the only way that you can not bear this pain, that you accept it that you committed the crime. So this is something inducement, and this inducement is from the person who is in the authority, and it is that any अवॉइडेंस ऑफ इविल ऑफ द टेम्परल नेचर। टेम्परल नेचर क्या है भाई? जब आपने एडमिट कर लोगे एंड देन यू विल बी पनिश्ड, तो पूरी जिंदगी आपको जेल में गुजारनी पड़ेगी। सो इट्स इन द टेम्परल नेचर। और थ्रेट देते हैं, या तो आप एडमिट कर लो वरना आपके भाई को भी पीटेंगे, पूरे परिवार को यहाँ ला के मारेंगे, लाइक इन द टाडा केसेस, मेनी केसेस इट हैपेंड। प्रॉमिस करते हैं कि आप एडमिट कर लो और हम अश्योर करेंगे कि आपको सजा बहुत कम हो, or of any nature. Now, why it is irrelevant? That is the basic question that we should consider. Because when the person is admitting and when this confession will be put in the trial, in the charge sheet, before the judge, he said, कि accused खुद कह रहा है he has committed, and no rational person would say anything against himself or that bring him to फांसी के फंदे तक ले जाए। how it is possible? But for that the confession must be voluntarily किसी ने accept किया हो then ना। But when it is through the inducement, threat and promise, this element of voluntariness has gone, and that's why section 24 says that it is irrelevant. And when such confession is irrelevant, section 5 says that the evidence of the relevant fact can be given and no other. So इसका evidence आप नहीं दे सकते। See the beauty. And so this is the confession that covered under section 24 has lost its nature of voluntariness. And in line with the section 24 of the Indian Evidence Act, there is section 163 in the CRPC. CRPC निकालो, find out section 163. इनके पास मोबाइल है वो अपना फास्ट मोबाइल में देखो, अभी मैजिक दिखाने जा रहे हैं। See, on the similar line, section 163 of the CRP says no inducement to be offered. This is the marginal note. No police officer or other person in authority shall offer or make or cause to be offered or made any such inducement, threat or promise as is mentioned in the section 24 of the Indian Evidence Act 1873, bracket 1 of 1873, because this was the first statute that passed in the 1872, that in that year. And so section 163 pose a duty on the police officer that you have not to make inducement, threat or promise through himself or through other person. That's why shall offer or make or cause to be offer or cause to be made. Cause to be means not by the some third person. Sometimes this tactic is done. Police wala, that officer is beating, and then वो भाई इसको चाय पिला दो, वहाँ पे चाय पिलाने आता है, वो कहता है भाई आप एक्सेप्ट कर लो, ये सारा पिटाई बंद हो जाएगी. बट ही कैन नॉट से अनलेस, वो थोड़ी अथॉरिटी में है, उसको तो कवाया जा रहा है. एंड सो shall offer or make or cause to be offer or cause to be made. या तो आप डायरेक्ट पुलिस ऑफिसर और पर्सन हु इज इन अथॉरिटी और द सम अदर हु इज इन द अथॉरिटी. So this is the mandate by the section 163 on the police officer or the other person who is in the authority. Now in the second clause of section 163 is, but no police officer or other person shall prevent by any caution or otherwise any person from making in course of investigation under this chapter any statement which he may be deposed to make of his own free will, provided that nothing in this section shall affect the provision of subsection 4 of the section 164. That is the saving. So the second clause is saying that if by the free will, apni ichha se, by the free will, any person, whether he is accused or other person, any person word is used, so there may be the witness or the other person. If by the free will he want to make the statement, that yes, I want to make the statement, then there is prohibition on the police officer or the person authority that they shall not prevent by any caution to depose him to make his, that by make his free will under section 164. During the investigation, if the accused or any other person want to make the statement by the free will, yes, they are free. And so the statement, if they want to make through in the investigation, they are free to make, but for getting that statement, you cannot use threat, inducement, and the promise. So that is the thing. Now the next question is the relevancy of the confession. And this is very important. That why a statement, there is confession, because the person who make it either admit it offense or at any rate admit all the fact that constitute the offense. Why this is an admissible? And the question is, and the answer is that a confession is admissible, relevant, because no rational person make a statement that used against himself, or that statement he admit the offense, unless it is voluntarily and as a regret he is making. Otherwise, no person will make it. And so, voluntarily, if a person is making that, is accepting his guilt, there is remorsefulness in his mind. If he is acting, then because he was the witness, he committed the crime, so such thing became relevant, because there is no other things to say that this statement, this confession is induced by some ulterior motive. And so when there is no other motive of the person who is making the confession, and just out of the remorsefulness, in the regret state, if he is accepting the crime, If he is confessing, then it is relevant thing. Okay. And so the important element here is the voluntariness. Because when there is no voluntariness, you cannot say that he make the statement of remorseful. नहीं भाई, उसको पीट पीट के करवाया गया accept. There is some other thing by which he is accepting the crime, he is confessing. And so in that sense, how you can say that it became relevant because the voluntariness is not there. उसने हो सकता उसने क्राइम किया ही नहीं, इसीलिए तो नहीं कर रहा था, लेकिन आपने इंड्यूस करके, थ्रेट करके, प्रॉमिस करके आपने वो जबरदस्ती करवाया है. And so when the element of voluntariness has gone, then the statement would not become relevant. Okay. And so the confession is relevant because confession is some statement by the person who was at the time of the crime, if you see from the other perspective, and out of remorsefulness, he is accepting all the things and telling the whole story. And so the prosecution, or as a rational person, as a what you say, rational man, you see that there should not be any other thing to prove when the person who committed the crime is voluntarily accepting and voluntarily, telling the whole story in which there is conclusively prove that he committed the guilt. Like there is the charges against the person A that A has murdered B, and A tell the story that there was the property dispute between A and the X. And so just to teach him the lesson that the X would not, take further action against that property, I went in the house of the X, and then I saw the knife, and then something happened, and then I stabbed this person. And so this whole statement is a confession, because the medical reports also said that he died, he succumbed to the death because of the injury caused by the stabbing. The intention also is saying that I went there to teach him lesson, and he stabbed him in the chest. That also the conduct is inferring about the intention. And so this became the confession. It is, if it is voluntarily, it is relevant. Okay. Now the next thing is the admissibility. As per the section 5, the relevant facts are admissible unless has not been expressly declared as inadmissible, and thus evidence of the relevant fact can be given and of no other. Then section 25 of the Indian Evidence Act said that it's like article 21, one line provision, but important. No confession made to a police officer shall be proved as against a person accused of any offense. So section 25 is not talking about relevancy. Maybe it was the relevant, maybe it was the voluntarily. And as we said, that when the confession is voluntarily, it is relevant. And so the question is that when a person is making the statement before the police officer, it may be the voluntarily and it may be the involuntarily कि police officer ने पीट पीट के उससे करवाया हो. There is both possibility. We cannot say that in all cases it is by threat or promise. ऐसा भी नहीं कि पुलिस ऑफिसर सब में ही करवाते हैं, but there is a greater evil, greater chances, and that's why section 25 is now saying that, because it's not actually listing that in those situations already in the section 24, that when there is the threat, the promise by the person who is in the authority, and that threat, promise or inducement in reference to the charges to either avoid the evil that is of the temporal nature. But here in the section 25, they are not listing the our lawmaker has not listing, but saying that yes, it may be relevant or irrelevant, it may be voluntarily or involuntarily, but it would not be admissible. Cannot be proved, that means it is not admissible. And so there is this difference. Then under section 26, the confession by the accused while in the custody of the police not to be proved against him. Here again, the confession that is made in the custody of police officer was not admissible. So section 25 and 26 are not talking about that whether the confession would be relevant or not relevant, because they are not concerned about assuring the voluntariness of the confession, but the larger perspective to stop or to avoid the larger evil by the investigating agency, because they are the part of that investigation. And if you see that they are one party and the accused is the another party, okay, and so in that light, the legislature has provided that no confession made by a person while he is in the custody of police officer is admissible, but there is the proviso in section 26 that unless it is made in the immediate presence of the magistrate, shall be proved as against the such person. So if it is, the person is in the custody, but he is, presence of the magistrate, that can be proved. Now there is another question, that what means by the presence. If you see the Ajmal Kasab or some type of the hardcore terrorist, and that person has not produced before the magistrate, so magistrate तो section 164 के according करेगा, वो through the video conferencing this thing is done. So the person is in the custody, and then through the custody there is the video conferencing, he's making the statement, and that is in recorded down. But because this whole thing is in the presence, here the presence does not mean the physical presence, and so it would become relevant. But now the question comes that सर जज साहब आते ही कैसे हम इंश्योर करेंगे कि वो जो फियर है उस बंदे के दिमाग में, पुलिस ऑफिसर ने डाला है पीट पीट के, रात भर उसको टॉर्चर किया है, सोने नहीं दिया है, कैसे अश्योर करेगा, कैसे करेगा? वॉलंटरीनेस होना चाहिए ना. So how something that is inadmissible certainly became admissible, and for that the legislature has provided the safe route, that it is duty of the magistrate to assure that there was the statement, the confession is voluntarily. Otherwise it would not become, it would be hit by the section 26. Section 20 saying that it must be in presence of the the magistrate. So when the magistrate is not present, the statement will hit by the section 26. But when magistrate present, he will also assure that the statement has to be made without fear, voluntarily. And he will assure, वो पूछेगा भी, भाई साहब जो आप कह रहे हो that can be used against you, फांसी के तख्ते पे ले जाएगी ये सब बातें आपको, आप पे कोई दबाव तो नहीं है ना? And sometime in the practice, because I was additional assistant district attorney, so I saw many trials that judge sometime make to sit that person in the chamber or some other place, बैठा दो इसको 10 मिनट बैठा दो, फिर हम statement लेंगे, so that that fear can be removed. Okay, because trial should be fair, and beating that person and forcing him to accept it, that is not a fair trial. Okay, so section 164, that recording of confession and statement. Section 163 clause 2 second is saying that if a person by his free will want to make a statement, any person, then the police officer or the person who is authority shall not cause any type of the will not prevent by coercion. And that means when a person want to make the statement, they will produce him before the magistrate. And under section 164, the magistrate will record the statement if the statement in itself is accepting the guilt as per the Pakla Narayan Swami. So that will be the confession, otherwise it would remain the statement. So any metropolitan magistrate or the judicial magistrate, MM or JM, कुछ अंतर नहीं होता है. रूरल और बाकी इलाकों में जुडिशियल मैजिस्ट्रेट होते हैं. जब वो सिटी बड़े शहर में हो जाते हैं जैसे दिल्ली वगैरह में, तो उसको मेट्रोपॉलिटन मैजिस्ट्रेट कहते हैं, वो जुडिशियल मैजिस्ट्रेट होते हैं. तो जेएम एंड एमएम, whether or not he has the jurisdiction in the case. It's also not necessary when a person want to make the statement or the confession कि वो जो उसका jurisdiction है उसके पास ही लेके जाएं. Anywhere the person can be produced. Record any confession. And why this is? Because if the person want to make the statement, पुलिस ऑफिसर के सामने होगा, नॉट एडमिसिबल. उसकी कस्टडी में होगा, नॉट एडमिसिबल. तो कहीं तो बनाएगा, अदरवाइज वो फिर रिकॉर्ड नहीं होगी, नहीं रिकॉर्ड होगी तो यूज नहीं होगी. एंड सो इट इज मैंडेटेड दैट टू द एनी मैजिस्ट्रेट द पुलिस कैन गो, द पुलिस ऑफिसर कैन गो and that statement can be recorded. That statement can be recorded in the in very quickly or in less time, because हो सकता है बाद में उसका भी मूड बदल जाए. नहीं, now we know I will not accept, I will not make statement. In course of investigation under this chapter or any other law for the time being in force at any time afterward before the commencement of inquiry or the trial. So after the inquiry or the commencement of trial, he can make the confession. So when he can make the confession, he can make the confession before the commencement of inquiry or before the trial. Trial start होने के बाद में confession cannot be made. And the confession that is made before this magistrate as per the section 164 will be known as judicial confession. The confession that is made before a person who is not a judicial magistrate is known as extrajudicial confession. In our discussion, we also discussed that what is extrajudicial confession, what is judicial confession. And believe me, there is huge difference, because judicial confession will be the substantive piece of the evidence, because judge तो वो ensure करेगा that there would be no involuntariness, no threat, no other type of the fear. But in the extrajudicial confession, उसका बाप आया कि मेरे सामने आया, बेटा आया था और रोता रोता कहा था कि पापा मैंने उसको मार दिया. So this is something extrajudicial confession. ये तो नहीं, इसका वैल्यू नहीं कि भाई उसने वॉलंटरली कहा कि इनवॉलंटरली कहा. And so that has to be seen with greater caution, because The judicial confession, or the confession in which judge can assure that it is voluntarily without threat or fear, can be the sole ground of conviction. और पुलिस ऑफिसर के सामने तो हुआ वो तो वैसे ही एडमिसिबल ही नहीं होगी. Okay. Section 164 that we were discussing. Section 164, then clause 2, that the magistrate shall, before recording any such confession, explain the person making it that he is not bound to make the confession. The magistrate will explain that he will not bound to make the confession, and that if he does any such confession, that magistrate shall not record the such confession upon questioning the person making it reason to believe that it is voluntarily, and he does the person making it, he is not bound to make the statement, and if he does so, it may be used as an evidence against him. भाई साहब, आप पे कोई दबाव नहीं कि आप कन्फेशन करो, और अगर करते हो तो ये आपके अगेंस्ट यूज हो सकती है. And then he will assure that it is voluntarily. There has to be the reason to believe that it is voluntarily. जज वहां उस पर लिखेगा भी कि मैंने देखा कि फिर रिलैक्स फील कर रहा था. And then section 164 clause 3, that if at any time before the confession is recorded, the person appear before the magistrate states that he is not willing to make the confession, the magistrate shall not authorize the detention of such person in police custody. And this is very, very important. Suppose there is some person and he is accused in the crime and the police has arrested him, police is beating him कि आपको जो है कन्फेशन करना है तो हम आपको छोड़ देंगे, नहीं पीटेंगे. वो भी सोचता है यार बहुत भारी पिटाई है, बहुत दर्द हो रहा है, चलो मैं कर देता हूँ कन्फेशन. नाउ पुलिस नोज कि हमारे बिफोर कन्फेशन किया तो सेक्शन 25 में इसका यूज ही नहीं, ट्रायल में फायदा क्या होगा. तो पुलिस उसको ले जाती है मजिस्ट्रेट के सामने. अब वहां तो बेचारा डर के मार से वो हो जाता है. यहाँ आके वो एक बार तो कहता, फिर कहता नहीं जज साहब मैंने तो नहीं किया. अब उसको ये भी पता है कि अब तूने मना कर दिया, अब दोबारा पुलिस के पास भेजा तो बेटा क्या सजा होगी. And so by way of precaution, there is section 164 clause 3, that at any point of time he is not willing to make, then magistrate will not authorize the detention. वो जुडिशियल कस्टडी में जाएगा, पुलिस कस्टडी में नहीं जाएगा. जो जेल होती है ना, जहाँ अंडर ट्रायल कैदी होते हैं, there this person will be put. Section 164 clause 4, just 2 minutes I will take. I know that I exceeded the time and that would create the the disturbance for you guys also. That any such confession shall be recorded in the manner provided in the section 281 for recording the examination of the accused person, and shall be signed by the person making the confession, and the magistrate shall make the memorandum in the foot of such recording. I have explained to the Mr. नाम लिखेंगे, he is not bound to make confession, that if he did so any confession, he make it may use be evidence against him, and I believe that this confession was voluntarily made. ये believe, ये भी लिखना पड़ेगा. I was taken in presence of hearing and was read over to the person making it, admitted to him the correct and contain the full and the true account of the statement, and then the such sign of the magistrate. So that memorandum also has to put. Any statement other than the confession made under shall be recorded in such manner, and this one. So section 164.1, 164.2, 164.3, and 164 are actually the procedural law to assure, to maintain the relevancy of the confession. That means to assure that there was no threat, no promise, no fear, and it was the voluntary statement. It was the voluntary confession, and that's why there is this procedure. There is the great duty on the magistrate, and you guys, believe it. मत भूल जाना वहां पे जब बन जाओ, because everything is playing with the life of the person who is under the trial. And so it must not be in the haste that you put the memorandum and then without assuring that this is something that is voluntarily. Okay. So that has to be done. Now see, now I'm stopping this class. I stop here, and in the next class we will discuss certain other things like the retracted confession. वो confess कर जाता है फिर दोबारा मुकर जाता है. Then whether the conduct would amount to the confession or no, inculpatory and exculpatory statement, and Article 20 Clause 3, because all these provision are in line with Article 20 Clause 3, that a person cannot be forced to make a statement that can be used against him or to make the inculpatory statement. Okay, so these are in line with, so that also we discussed. Then we will discuss the judicial confession and the reliability of judicial confession, or you can say the evidentiary value of judicial confession, extrajudicial confession, etc. And after that, on the section 24, we will discuss one Veera Ibrahim versus State of Maharashtra case. We will discuss that also. So these were the something that we will discuss in our next class. Today we have discussed certain thing. The first is what is confession, and for that the Pakla Narayan Swami and the Palvinder Kaur versus State of Punjab, these two judgments you can download in the on the Indian Kanun, or in the case material also in the CBI versus this VC Supla, you find these judgment there, you can read it. The relevancy of the confession, why it is relevant, because no rational person that reasoning behind that, and then because it is relevant, so by section 5 the evidence can be provided, and something that is not relevant, the admission cannot be given, like the section 24. Then the admissibility, the section 25, and then the two procedural the law, the section 163 and section 164, just to assure and to maintain the relevancy of the the confession. So these things we have discussed today, and rest we will discuss in the next class. With this, my lecture is over, and I am giving you the 2 minutes. You can share if you have any problem with the any problem in the today's class today.